Hello, I am Dr. Rajshree Chatterjee, Associate Professor, Department of Journalism and Mass Communication, Jagannath University, Jaipur.
Today I am going to discuss Sedition Act, Section 124A of IPC. Now the point is, why recently Sedition Act was in news? The Law Commission is in the process of revisiting the Section 124A of IPC. It calls for a thorough reconsideration and presents the various issues related to it before the public for a national debate. Now let's discuss what is Section 124A of IPC. Section 124A deals with sedition and was introduced by the British colonial government in 1870. It says that the act of sedition is to bring hatred or contempt towards the government established by law in India. In this case, the punishment may be of imprisonment for life and fine, or imprisonment for 3 years and fine. It was actually brought to suppress the freedom struggle prevalent then. Now, what does the previous Law Commission report says? In an earlier report in 1868, the Law Commission has rejected the idea of repealing the section. In 1971, the panel wanted the scope of the section to be expanded. It called for covering the constitution, the legislature and the judiciary, in addition to the government to be established by law. It meant that disaffection against all these institutions should not be tolerated. The only dilution is mooted was to modify the wide gap between the two jail terms prescribed, either 3 years or life. It called for fixing the maximum sanction at 7 years, rigorous imprisonment with fine. Now, what are the concerns? Let's discuss the purpose. It is an irony to retain a provision that was used extensively to suppress the freedom struggle. It is to be noted that Britain itself abolished it 10 years ago. Also, there have been repeated instances of misuse of the section. Let's discuss the definition of sedition. The foremost objection is that the definition of sedition remains too wide. Under the present law, it offers scope to consider as seditious, strong criticism against women policies and personalities, slogan voicing disapprobation of leaders, depiction of an unresponsive or insensitive regime. In recent times, the core principle enunciated by the Supreme Court in this regard has been forgotten. It specifies that incitement to violence or tendency to create public disorder are the essential ingredients of the offense. Now let's look at what is the way forward. As long as sedition is seen as a reasonable restriction on free speech, on the ground of preserving public order, it will be difficult to contain its mischief. There are thus two ways of undoing the harm that sedition provision does to citizens' fundamental rights. First, it can be amended so that there is a much narrower definition of what constitutes sedition. And the second is, best course is to repeal the sedition altogether. These are the suggestions that have been given so far. Now, what is its validity? Section 124A has been challenged in various courts in specific cases. The validity of the provision itself was upheld by a constitutional bench of Supreme Court in 1962 in Kedarnath State, Singh versus State of Bihar. That judgment went into the issue of whether the law of sedition is inconsistent with the fundamental right under Article 19(1)(a). Under Article 19(1)(a) guarantees freedom of speech and expression. The Supreme Court laid down that every citizen has a right to say or write about the government by way of criticism or comment. It also added that this comment shouldn't incite people to violence against the government established by law or with the intention of creating public disorder. The Supreme Court ruled that casual raising of slogans once or twice by two individuals alone cannot be said to be aimed at exciting or attempt to excite hatred or dissatisfaction by the government. Now let's discuss what is the Maharashtra Circular. In a 2015 circular, the Maharashtra government laid down the preconditions to its police personnel before invoking sedition. The circular came during the hearing of a public interest litigation in the Bombay High Court after a cartoonist was booked for sedition. The sedition charge was subsequently dropped by the police. A PIL was filed in 2015 on the alleged arbitrary application of the charge. What the High Court said. In 2015, the High Court referred to the Kedarnath judgment and said there was a need to lay down parameters for the invocation of Section 124A. Otherwise, a situation would result in which an unrestricted recourse of Section 124A, resulting in a serious encroachment of guarantee of personal liberty conferred upon every citizen of a free society. However, the court said it did not feel the need to dwell on the subject further. It said so due to the fact that the then state government has proposed that it would issue guidelines in the form of a circular to all its police personnel for the invocation of Section 124A. Now, what are the state guidelines? The circular was issued and its guidelines included preconditions to be kept in mind while invocation of 124A. The preconditions were the words, signs, or representations must bring the government into hatred or contempt or cause or attempt to cause disaffection, enmity, or disloyalty to the government. Along with this, it must also inciting violence or tend to create public disorder or a reasonable apprehension of public disorder. The comments expressing criticism of the government with a view to change the government by lawful means without any of the above are not seditious under Section 124A. To ensure that the section is used arbitrarily, the circular directed that the legal opinion from the district law officer should be taken by the public prosecutor addressing fulfillment of these conditions. Now let's discuss what are the charges of recent concerns. There have been many incidents in recent times where misguided people have been termed anti-national. Law enforcement agencies forgot the fact that the sentiment could have been demonstrated through a slogan, a cheer, a statement, protest against a nuclear power project, or innocuous post on social media. In all these cases, the state also regimes the file charges of sedition. Authorities often forget the fact that sedition can be applied to instances of criticism of the government or a political functionary. More importantly, word alone are not enough for such a charge to be slapped. Incitement to violence is the most crucial ingredient of the Office of Sedition. Going through the numbers of the National Crime Record Bureau puts out every year, it is clear that despite the rise in sedition cases, conviction happen in barely a few. Even if these peoples are not convicted, the slapping of these charges is a way the government over the years have been sending a strong message to its own people. Obey or be ready to face consequences. Now, observation made by Supreme Court. In 1962, the Supreme Court decided on the constitutionality of Sedition 124A, section in Kedarnath Singh versus State of Bihar. It upheld the constitutionality of sedition but limited its application to acts involving intention or tendency to create disorder or disturbance of law and order or incitement to violence. It distinguished these from very strong speech or the use of vigorous words strongly critical to the government. In 1995, the Supreme Court in Balwant Singh versus State of Punjab acquitted persons from charges of sedition for shouting slogans such as Khalistan Zindabad and Raj Karega Khalsa outside a cinema after Indira Gandhi's assassination. Instead of looking at the tendency of the words to cause public order, the court held that mere sloganeering, which evoked no public response, did not amount to sedition, for which a more overt act was required. The accused did not intend to incite people to create disorder, and no law and order problem have been occurred. Now let's discuss few cases which are related to sedition. The latest victim of Section 124A, a 19-year-old girl, Amulya Leona. Bangalore police arrested her for saying Pakistan among the countries where she hailed as Zindabad in a public forum. All Amulya did was indulge in sloganeering, shouting, and the Supreme Court held in a 1995 case that mere sloganeering does not amount to sedition. There seemed to be no application of mind by either the police or the magistrate in that case. Nor does the arrest pass the test of the Supreme Court's guidelines for a prima facie case. Even before Amulya's arrest, more than a score of people in Uttar Pradesh, Assam, Karnataka, where the police interrogated school children over a play, and Manipur have been taken into custody for sedition. In these cases, too, there seemed to be a flagrant disregard of the Supreme Court's guidelines. Clearly dissent, criticism of the government, questioning politicians, all of these are fundamental to a democracy. Here have come to be treated as sedition by the police and a section of the magistracy. In the prevalent political order, such terrorizing of critics and protesters endangers the very idea of democracy. The blatant use of Section 124 in addition to Section 144 to crack down on political dissent have once again raised a clamor for scrapping it. In recent years, the section has been slapped against public intellectuals, scholars, students, authors, writers, activists, and a host of eminent figures. This has been going on even before the BJP took office at the center. In years past, the charged include Arundhati Roy in 2010, Binayak Sen in 2007, cartoonist Asim Trivedi 2012, and politician Praveen Togadia in 2003, and Simranjeet Singh Maan in 2005. The Tamil Nadu police slapped sedition cases against thousands during the protest against Kudankulam nuclear power project in 2012 and 13. Decades earlier, in 1980 and 81, when, in the name of curbing Naxalites, Tamil Nadu cracked down on civil liberties activists and agricultural labor, hundreds of people were charged with sedition. The ruling at the center was a silent spectator when states used Section 124A as an instrument of political repression. Although in its 2019 Lok Sabha election manifesto promised to do away with Section 124A, had it been earnest about revoking this much misused law, the Congress had ample opportunity to do so during UPA's 10 years and even earlier. Nehru himself had spoken out against Section 124A, and there were court rulings and law commission's reports to junk the law, far from acting on any of these. The ruling Congress did not even intervene against the misuse of Section 124A between 2004 and 2014. So here in this topic we have discussed that what are the provisions of sedition, what are the penalties and imprisonment that could happen for sedition. We have also discussed few highlighted cases and what could be the possibilities of sedition in India and how it can be removed so that it cannot go against democracy. Thank you so much.